Hello guys, and welcome to another episode of my lecture. On today's episode, we would be talking about the Nigerian cases under the old Act. Then after that, that's the subsequent video after this one, we'll be talking about the Nigerian cases under the new Act. So let's quickly go to our series of cases. Now, like I said in my last class, Nigerian courts have been reaching decisions on Res Gastae rather than Section 7. Let us start with the case of SULE SALAWU versus the states. People heard cry, "Sule is killing me," in a room, and they found the deceased dead in a pool of blood. The West African Court of Appeal held that this statement was admissible under Res Gastae. Now let's go to the case of Sunday AKPAN. You would note that under SULE SALAWU versus the state, they used the strict contemporaneous rule because it was as he was killing him that he made the statement. Now we go to the case of Sunday AKPAN versus the state. A 12-year-old boy testified he heard his mother shout, "Sunday has killed me," and he saw A cutting R with a machete. The court held that it was admissible. That still was admissible under the Res Gastae Doctrine, as it is the strict contemporaneous rule. Now you have the case of Udo versus R. Here D got injured after A had assaulted her. The neighbor's wife met him trying to treat her and asked what happened. D said A put his hand between her legs, carried her up and knocked her to the ground. She reported this to her brother the next day. The court held that it was not part of Res Gastae. Now in the case of OKOKOR versus R, the witness heard D exclaim, "Ovu Marimu has killed me," and saw him in a pool of blood while A was trying to run away. The court held that this was part of Res Gastae. Now, if you are going to look at a trend between what has been going on, you see that instead of them to admit under Section 7, they were admitting under Res Gastae. That's the reason Udo versus R, where the incident had happened, and then the neighbor's wife came and said, what is going on, and all that. And then she explained to her that, "Oh, he carried me, he knocked me on the ground like he's John Cena, and now I am injured." The court held that that was not forming part of Res Gastae because it wasn't said at the time when the thing was going on. And not just that, there has already been time lapse and there could have been concoction of stories. But that is not a condition that has been stated in our own Section 7, that's of the old Act. That's not a condition. Whether or not there has been concussion of story is not a condition. What is the condition is whether or not that statement can be said to be forming part of the transaction, which means part of the happening. Do you understand? When he hit her and all that, did it explain, did it shed more light on who hit her, on whether she was carried and all that? Once the answer is yes, then whether or not the fact has been concocted is not the business of the court, because Section 4 of our new Act and Section 7 of our old Act does not make it a condition. Do you understand? So we then move on. Now, from the foregoing, it seems that our court adopt the strict contemporaneity rule as laid down in R and Bedingfield, and this results in rejecting evidence which ought to have been relevant and admissible under the Act, as seen in Udo and R. In OKOKOR versus the state, Idigbe GSC had warned against applying the principles of English law in the face of local provisions on the same matter, but yet he still went ahead to admit evidence as part of Res Gastae and not Section 7, even after warning that the court should make sure that where there are local provisions on the subject matter, they should not apply the principles of English law. But he himself still applied the principle of English law, disregarding Section 7 while applying Res Gastae Doctrine. Now, even if the court decided to follow the common law doctrine, they usually restrict their reasoning to the strict contemporaneity rule, even when English law has advanced beyond the position. Now, RATTEN and R has been decided as far back as 1972. So it is a wonder why our court, after years, still refer to the common law doctrine as it was obtained before 1970. In the case of IKOMI versus the state, the court rejected evidence based on Res Gastae and not Section 7 of the old Act, and it can be argued that a different decision would have been reached had the latter been used. Even if Section 7 of the old Act is not a codification of the Res Gastae Doctrine, the court ought to be using section 7 as the basis for admitting or rejecting evidence. So as we have seen so far, we have seen series of cases on the old act. They basically disregarded section 7 and they were just admitting Res Gastae Doctrine over and over and over again. But let us look at the new act. What is the disposition of the court to section 4 of the Evidence Act? That I'll be discussing in my next lecture. See you in my next lecture.